Ecological Food and Farm Association, and the series of webinars that we're doing a monthly series of webinars on business-related topics for farmers, and we'll have more scheduled throughout the year. But you can access our past webinars on our website, and we have topics such as food safety, as well as setting prices for your product, and also setting a mission statement for your business. So I encourage you all, if you weren't able to participate in those, to visit our website and check those out when you have time. Our presenter this evening is going to be talking with us about employees on your farm and the process for accepting employees or bringing employees onto your farm and the legal ramifications of that. And our presenter is Thomas Green. He's a shareholder and vice president of Kastner, Westman & Wilkins, LLC. And their firm is based in Akron, and it's a boutique employment and labor law firm representing management exclusively. Tom is an Ohio State Bar Association certified specialist in labor and employment law, and his practice is focused on representing public and private employers' interests in all aspects of workplace law, including litigation of employment and non-compete agreements claims, labor arbitrations, labor negotiations, day-to-day client counseling, and so on. So we're really thrilled to have someone with his in-depth background of employment law spending some time with us this evening. A couple of pieces of housekeeping here. You can type your questions into me at any time on the box on your screen where it says questions. You can send in questions throughout the presentation time, and Tom will actually be stopping periodically to answer questions. But again, just feel free to type your questions in at any point. Also, at the end of the presentation, you will get a pop-up for a survey, and this survey helps us immensely with our grant reporting requirements, so we do appreciate it very much if you can take just a few quick minutes to fill out that survey at the end of the presentation. So without further ado, I'd like to welcome Tom and turn it on over to him. Thanks, Tom, for joining us this evening.
Okay, good evening, everyone. This is Tom Green. I'm happy to be here this evening and join you and talk about hiring employees and how you go about that process. I'll give you a little bit of an idea about what we're going to cover today. Whenever I do a presentation, I always stress that it's more important for you to get your questions answered than it is for me to tell you things certainly than you already know or that you're not interested in. So by all means, take Beth's lead and type away with questions. If they stray a little bit from the outline today, that's fine, so long as they're within the ambit of employment law. I'll take a crack at answering, or else if I don't know the answer off the top of my head, I might ask you to send me an email afterwards. I can find the answer and then shoot it back to you. So, so here's an idea what we're going to cover today. First, we're going to cover the difference between an employee and an independent contractor. I'm sure all of you have heard those terms passed around, and we're going to give you an idea of which is which and when you need to have one and when you shouldn't have one, and so on. And then we'll go on to how you actually hire employees. So if you decide you need somebody, and by that time we'll have already discussed the difference between an employee and a contractor, and we can give you some guidance on the steps to take to hire an employee. Then we'll talk about what you do after you hire the employee. There's some legal requirements as to paperwork and whatnot, and that you need to take care of after you hire an employee. And along the way here, we'll also talk to you about as I go through which of these items are required by the law, which of them are best practices, and which of them, even though they're not required and maybe they're not even best practices, they're just really good ideas that I recommend even small employers go with. And then finally, we'll talk about how you pay employees and what you're obligated to do, how often you're obligated to pay them, and that type of thing. So without further ado, we'll get started. And again, the first topic here, and I'll switch the screen, is employee versus independent contractor. All right. So kind of the baseline when you start talking about employee versus independent contractor is to keep in mind that you can't get burned by defaulting to and considering somebody an employee. You can really only get in trouble if you consider someone who is really employee, but you consider them to be a contractor. So hopefully that makes sense. So I guess another way to say that is, if you're not sure, you need to, the safer course of action is to go towards considering somebody an employee, and more importantly, treating them under the law as an employee. And we'll talk about that here now. So, so what's the difference between an employee and an independent contractor? Well, it depends on who's asking. And what I mean by that is, for some tax purposes, the IRS has its test about 20 factors on how to determine which is which. When it comes to wage hour issues, the Department of Labor or a court, they might have their factors on how to determine whether someone's an employee or a contractor. But when it comes right down to it, the test simplified, it's usually obvious if you're one or the other. So you can kind of boil those, all those tests down to just a few factors. One thing here I noted on this slide is and this might be the most important thing about it, is it just isn't what you call the employee. No more than you can say, you can have two horses next to each other and you wouldn't say, well, the one on the left is a horse, but the one on the right is a cow. That doesn't make the horse a cow. You can't just call somebody a contractor and cross your fingers and hope for the best. That isn't going to get you very far in the long run. All right, so now we'll talk about the factors again, boiled down. So this is boiled down from what the Department of Labor and the Internal Revenue Service might look at. It boiled down to the balance between the employer control and the worker independence. And we can, we'll talk about that a little bit here, but here's some other sub-factors: is who sets the hours of work, may the worker subcontract the work, and is there a signed independent contractor agreement. So we'll kind of go through these one at a time. Big picture though, keep in mind kind of your common sense that you have in running a household and running a business and other occupations that you may have been engaged in either while you're doing your farming or before you got into that line of work. If you have a house and you hire a plumber to fix one of the house's toilets, and for the sake of discussion, let's say the house has one toilet, and the plumber comes over, he spends a half hour with you, and then he leaves, and you don't call him again for 3 hours. That's easy. So we think about this as a continuum. That person is clearly an independent contractor. He's not working, you're not setting his hours of work. When you call the plumber, the plumbing company, they can send whoever they want, so there's a subcontracting, kind of element there, and they'll invoice you. Although there won't be an independent contractor agreement, they will invoice you for that work. They won't expect to get a paycheck with taxes deducted and everything. So that's on one side of the spectrum. But staying with the plumber here for a second, say if you owned an office building that had 1,000 toilets, you might need a plumber so regularly that that plumber becomes your employee. So that's kind of the reality check you need to do, is are you controlling the plumber, and if so, In the office building example, that plumber's an employee. If you're just calling that person from time to time for services on an isolated basis, that person is an independent contractor. And the gray area is obviously where the rubber meets the road, and we can talk a little bit more about that in the next slide. Here's some other factors to consider. Is the worker provided training? Is there a continuing relationship? That goes back to the plumber example I gave you. Who furnishes the tools and equipment? And does the worker perform similar services for others or work exclusively for one business? We'll kind of work through those from the bottom up. If somebody is working for you and only you for a multitude of reasons. One, if he's working for you and only you because you told him or her he can only work for you, chances are that person's an employee and not a contractor. If the person is working for you and only you because you told the person, hey, or I'm sorry, because you're using so much of the person's time that they don't have time to work for anybody else, that person's probably an employee too, because that looks more like an employment relationship and not an independent contractor. Keep in mind that one of the two words in independent contractor is independent. So if this person's working for you all the time, chances are they're not independent. Up to the tools and equipment. If you're furnishing the tools and equipment, again, none of these factors are dispositive, but if you're furnishing the tools and equipment, the person is probably an employee. Back to the plumber example. The plumber shows up and he's got a truck with all the pipes and the tools and everything, and he comes in and all you do is show him where the toilet is and write the check when he's done. He's furnishing the tools and equipment, and that's more like a contractor. If you were providing all the tools and equipment, like you might be if someone was working for you 30 or 40 hours a week on your farm, then the person is probably an employee. Is there a continuing relationship with the worker? Again, back to the plumber example. If you need to have somebody come in to do a certain task on your farm, and the person comes in and works for you one time per year, probably a contractor. One time per month, still probably a contractor. Once a week, still might be a contractor, but getting closer to an employee. Every day or 3 or 4 days a week, probably an employee. Is the worker providing training? Again, if the answer to this question is yes, you're providing the training, that's more like an employee. Back to the plumber example. If the plumber shows up, you don't teach him how to fix the toilet. He already knows how to do that and takes care of it. That's why he's a contractor in my example with the household toilet. But on the other hand, if somebody comes to you and says, I'm out of work, I'm interested in working on your farm, but I've never done it before, and then you spend the first 2 weeks or maybe 2 months training the person to do the work, that's more like an employment relationship. We just got to skip back to the last slide here to see if I want to add any more detail to those factors. Yeah, let's talk about the hours of work just for a minute more. If you're setting the hours of work, that's more like employment. If the person just gets their calendar out and says, oh, I'm available on Thursday afternoon, and you kind of take what you can get, that's more like a contractor. Subcontracting we touched on a little bit, but if you hire a company to do paint a barn at your farm or put up a fence, they can kind of bring whoever they want to do the work. That's more like a contractor. But if you have somebody that works for you 5 days a week, 10 hours a day, doing a task at the farm, you probably wouldn't care for it if they didn't show up for 2 weeks and sent their cousin instead to do it, even though they had no idea what they were doing. Again, subcontracting is more like independent contractor, not employment. And then finally, the signed independent contractor agreement. It's a close call. One thing that you might want to consider doing is having it memorialized in writing that you consider this arrangement to be an independent contractor arrangement. and some things you have in those, and they're different on a case-by-case basis. In an independent contractor relationship is a disclaimer that the contractor is providing his own insurance and own workers' compensation insurance, and that he doesn't expect you to withhold taxes from his pay and things along those lines. So that's something that, again, is very particular depending on how close of a call it is with the contractor and what the terms of that agreement are. All right, so I mentioned at the beginning, if it's a close call, the safe route is to default to considering the person, the individual, an employee. You might say, well, why would I want to do that? Well, the reason you want to do that is because if you treat somebody as a contractor and then you later are challenged on that decision, and a court or the IRS, for instance, decides, if in the case of the IRS, that you should have been treating them like an employee, then you would have to go back and pay unpaid payroll taxes, Social Security and Medicare contributions. The IRS doesn't care about the unemployment and the workers' compensation, but that's also something you could be on the hook for, as well as unpaid overtime, which is the Department of Labor and a corresponding Ohio agency, and then penalties go with all those. So you want to be right when you come out of the box here and determine whether you're hiring an employee or a contractor. All right, so that's the material on the employee versus independent contractor. We have a little more material here on apprenticeships, which we're going to go to next. That was a specific topic that the Countryside Conservancy asked me to speak on, but I encourage you to, if you have questions about what we've covered so far, to fire away. All right, now apprenticeships, they're common in the, especially in the construction trades, and frankly, the construction trade clients that we have here at the firm that are unionized oftentimes have a relationship through the union with a trade apprenticeship program. Now here's what you need to know, I think, about apprenticeship programs. Is apprenticeship programs, when I'm using that term right now, is a technical term, and that's a term under the Fair Labor Standards Act, which is a federal law. And it requires a lot of work to get an apprenticeship program going to meet the qualifications under the Fair Labor Standards Act. And why you would want to do that is because you would want to pay the employees perhaps less than minimum wage, because they're learning kind of as they're progressing. But as we'll talk about later, the minimum wage and overtime regulations may not apply to employees that you hire in an agricultural setting. So I wouldn't get too hung up on the fact that the burden of an apprenticeship program is very high, because I really don't think that most small farmers would want to even bother with that. That is probably not worth your while. Now, does that mean that you can't hire somebody to learn beside you while you operate your farm? No, it doesn't mean that. And if you really want to call them an apprentice, you know, knock yourself out. All it means is you can't qualify, probably, or at least not without a lot of work, for an apprenticeship program that qualifies under federal law. But I'm telling you, it's probably a distinction without a difference for most of you. So I think we were going to take a brief stop there about after we hit apprentices, and I see Beth sent out a message about questions. Beth, I'll just throw it back to you for just a minute.
Yeah, I haven't received any questions, but if anybody has any, feel free to jump on in and send those to me so that we can make sure that we're getting your questions answered here.
All right, so the next topic is effective hiring practices. All right, so now kind of bringing us up to speed, we've talked about the difference between an employee and a contractor. We touched base on an apprenticeship. But let's assume right now that you are going to hire somebody to work with you. And how do you go about doing that, and how do you go about doing it lawfully? All right, well, here's a few things that we'll go through on effective hiring practices, and I'll try to give you an idea on which of these are required as opposed to just guidance or best practices. So as far as this checklist here I have for you, this may seem pretty basic, but it does kind of give you a roadmap for what you need to do and what sequence to do this in. I think the first thing to do is you identify what the job is that you want done. And don't worry about titles or anything like that, but you can call it whatever you want. And then, this doesn't have to be fancy, you want to scratch down on either on a Word document or even on a notebook what exact job duties you're going to have the employee do. And then you decide where you're going to get the applicants from. And it would depend on probably the nature of the work that you're looking to fill. Now this would matter probably more if you were a larger employer, but it's certainly worth keeping in mind. You really only want to accept applications for jobs that are open. So if applications come in, say you fill 2 or 3 jobs for a season, somebody sends you an application the next winter, and you already have the jobs filled because everyone's coming back for the next season, you shouldn't be accepting applications at that point. It's kind of a bad practice to say you'll keep applications on file indefinitely. Kind of a middle ground is to say that you'll keep applications on file for a certain fixed period of time, and then you can discard them. But I wouldn't just accept applications willy-nilly indefinitely. All right, so then you're going to get your applicants. We'll talk a little bit about what you ask for from an applicant. You can have an employment application, which we'll talk about in a little bit, or you can simply just have an employee send in a resume that lists their qualifications for the job and their work experience. In any event, you need to screen those and set up interviews. You can do telephone interviews, in person, however you want to do it, and then do the interviews themselves. We'll talk a little bit about some of the things where you could get in trouble during this process here as we move to the next slide. All right. So now several of these things listed on this slide are completely optional, but I wanted to let you know that they were out there. You can do reference checks on your finalists that you have received applications from. You don't have to do that, but you can. Most employers these days will only give you position held, dates of employment. Some will give salary information. But you doesn't stop you from asking if you want to do that, because some employers will tell you, stay away from this person, or just the opposite, this person's a keeper. Aptitude testing, is it possible that you'd want to do that? Yes, maybe not likely though. After you go through the process of selecting candidates and finalists, and then interviewing and extending a conditional offer to the most qualified candidate, you can, but do not have to do pre-employment drug testing or pre-employment physical. If you have questions about what that would entail, we can get into that in more detail, but this is certainly not a requirement. I'm just kind of presenting you with some options that you're allowed to do as an employer when you extend a conditional offer to a candidate. If you're not going to do a pre-employment physical or pre-employment drug test, then the offer really wouldn't be conditional. You could just hire the person after you agree on the hours of work and the pay, and bring them on. So we'll move on to the next slide here. All right. So now you've brought somebody on board. You have hired somebody onto your farm to work your business, and some of these things on this slide are critical that you do, and they are required by the law. So these parts here are very important. The first one is to complete an I-9 form, which includes a portion for you to complete as the employer, and also a portion for the employee to complete. And you're probably familiar with an I-9 from maybe jobs you've held in the past. The I-9 is administered by the Department of Homeland Security, and specifically the U.S. Citizenship and Immigration Services Unit. And it's to make sure that the employee is eligible to work in the United States. And there are instructions that take you right through. This form recently changed, maybe about a month or two ago. And there's instructions that lead you right through on what documents you need to check, how to fill out the form, etc., and then where to file the form. This is good to get out of the way on the first day, and then you need to get this filed, I believe, within the third day. So that's available online at the United States Citizenship and Immigration Services website. And I believe for some employers you can do it electronically, but printing it out and having it filled out is just fine. Okay, and I said filing it. I think I misspoke. I haven't done one of these in a while, but I think you just keep these on hand in the case you're audited. So forget about what I said about the filing. All right. Now we're going to talk about the filing with the new hire reporting form. I got my wires crossed there for a second. This is relatively new, at least compared to the I-9. This has probably been around for maybe 10 or 15 years. Is the new hire reporting form. Now, this came out, like I said, not that long ago. And the basic purpose of this is, as I understand it, is to report folks that you've hired. So they go into the central database to make sure that they aren't receiving government benefits while they're working for you, but they're telling a government agency that they're not working. That's one purpose. And I also I think they use it to cross-check for folks that owe child support, maybe in a different jurisdiction. In any event, one thing important to note about the new hire reporting is you're required to fill this out for not only employees, but also independent contractors that work for you. And you're to do that for newly hired employees, rehired employees, and et cetera. The form's pretty easy to fill out. It's kind of self-explanatory. And then there's instructions on the Ohio Department of Job and Family Services website, where to file this. Actually, there's instructions right on the form as well, and you can access the forms through the ODJF website. We'll send you to the Ohio New Hire Reporting website, and there are materials there to complete. And down to the third point here, the completed post-offer questionnaire. This is something we could get into in more detail, but this is optional. First two required, third one optional, and this could include things like their medical history. There's very limited times when you're allowed to ask about medical history. This is one of them, and related issues to that. Again, this is not required, only optional. And then moving to the last one on this form is the Form W-4. This is an IRS form, again, which you're probably familiar with. And this is a required form that you have completed so that you know how much taxes and whatnot to withhold from payroll. So this would be for employees only. Beth has a question. Yeah, so let's see here. I think I just go.
So one of our participants is asking if they have the same person returning every summer. They've had them come back, you know, for many consecutive years each summer. Do they need to go in and update something each year with those forms?
With the new hire reporting form, let's see, let's go through this one by one. With the I-9, I do not believe with the I-9 that you have to go back and check, but let me see here. Let me just, on the fly, if I could pull this out. You know, I would want to check to be sure. Oh, here we go. When rehiring an employee within 3 years of the date the I-9 was originally completed, employers have the option to complete a new I-9 or complete Section 3, which is a specific section about rehiring or re-verification. So there's, I think, is your answer within 3 years. So from reading the opposite of that, if the employee comes back and it's further out than 3 years, I think you need to start over. That's on the I-9. On the Ohio new hire reporting, that specifically says that you need to report it when the employee returns to work and within 20 days. So that would be each summer. That and the W-4, so long, that's really just for your so long as the person's dependent and marital status has not changed, you can probably just let that go. With the one you have on file, as a practical point, probably the way to do it is to, when the person comes back, is if you don't know whether they're still married or have become newly married or have had children, you may just want to ask, and if there has been a change, you can ask them to change the W-4. So hopefully that answers those questions on somebody coming back each summer. That's a good question. All right, so let's see here. All right, so we're moving on to, oh, one more thing before I forget. If you're starting and you've not had employees before, ever, and you're starting by hiring one to begin with, most of the time, your CPA can help you with this. I've kind of learned that the CPA is the person in someone's life that pushes them in the direction to know about this, but I'll mention it in case you happen to be doing your own accounting or your CPA doesn't. is you're going to want to, when you get your first employee, and frankly you probably want to do it now, the more I think about it, even if you're just self-employed, is purchase a insurance policy from the Ohio Bureau of Workers' Compensation. And this is going to cover work-related injuries and illnesses. And as an Ohio employer, you're required to carry insurance and workers' compensation insurance. And there's only one place that you can buy it from, and that's the Ohio Bureau of Workers' Compensation. And if you go to the Bureau's website, I've not bought it for myself, but I know some people who have bought it for nannies and whatnot. I'm guessing that that is not something that is difficult to do, and I'm told that if you have just a very small amount of payroll passing through your company, that the cost of coverage is not that high. And then they'll give you a certificate of coverage, and the way that works, very briefly, is workers' comp is what's called a no-fault system in Ohio, meaning that if the employee gets injured or ill in the course and scope of their employment, that's how the law defines that, then their medical costs and in some cases compensation for lost time is paid out of that insurance fund. So that is if you're starting from scratch and you don't have any employees and you're just starting. And frankly, if you have employees now and you don't have a BWC coverage, tomorrow would be when I recommend that you purchase those, because if you don't have coverage and there is a work-related injury and a claim is filed, you basically become self-insured, which means you're on the hook for all the costs of the claim, of the injury or illness, and there are penalties for not having the insurance. So, so that would be a good first step when you're bringing on employees. Okay,
so Tom,
so yeah, go ahead.
Tom, jumping back to the I-9 quickly, there's another question as to whether or not the I-9 is required even for high school-aged employees.
Okay, let's see here. I think it's required for all employees. I have never heard, well, it's only been, I have never heard of any exceptions for the I-9, so someone would have to talk me out of that. I would do that, the I-9, I would do that for every employee. Yeah, I've never heard of any exception for that. It's a good question, but yes, I would do that for each employee. Let me just check here if I can find something a little more definitive. Oh, here we go. Well, these instructions are very, very thorough. There's a heading on page 2 of the form that talks about parents or legal guardians who are assisting minors, and it lists them as under 18, and employees with disabilities as far as assisting with the completion of the I-9. So they're definitely contemplating this being done for employees under the age of 18. Was that the only question, under 18?
Yeah, that was it as far as the I-9 questions thus far.
Okay, good. All right, so let's go on here. A couple other things to consider after you've hired an employee. And this next one is kind of innocuous the way it's written up here on the slide, and it is optional, but I think this is one of the most important things you can do. It's probably also one of the easiest, and and it's something that really I wouldn't recommend any employer do without. You can call it here as it is an employee statement or an acknowledgement. You can even call it an employment contract if you want. But what you want the employee to sign, and I just did this, I just helped an employer with this very issue, is having the employee sign off on a statement, we'll call it, or an acknowledgement that says just a few things, but there are a few important things. And one thing is what the rate of pay is, and whether there's any fringe benefits. So it's kind of like an offer letter, but if you only have a few employees, I kind of work the offer letter and this acknowledgement all into one document. So you just memorialize what the pay is going to be. Is it going to be by the hour, by the week, whatever? Are there any fringe benefits? And another good thing is kind of coming full circle back to the beginning when we're talking about hiring somebody, and I said you could scratch down what the job duties are on a notepad or on a Word document. You have an acknowledgement that the employee's duties are on the attached job description, and again, depending on the sophistication level of an employer, the job description doesn't have to be really anything special, but it does have to be an accurate description of what the employee's duties are. Do you have to have a job description for each employee? No. Is it a good idea? Yes, it's a very good idea for lots of reasons. Another thing, this might be the most important one, is an acknowledgement that the employment is at will, which means the employee's employment can be terminated with or without notice and with or without cause by either the employee or the employer at any time. And you just, so that way there's no expectation that they said, well, I thought this was going to go on forever, or I thought you needed to have a really good reason to get rid of me, or anything. It's at will employment. Another important thing, and this may seem like overkill, but believe me, if you've ever lived through or been involved with a claim of sexual harassment or racial harassment, those can get very ugly. And one way to manage liability with those types of things is to have an anti-harassment, anti-discrimination policy with a reporting mechanism that says exactly who you need to tell if you believe you're being harassed or discriminated against, and who to report it to, and you just clip that right to the acknowledgement also, and that's very important. And then the last thing, and this has been something I've been recommending maybe for the last 5 or 6 years to anybody who's asked, is a notice, and you need a little more legal mumbo jumbo to put this one together, but a notice that to employees that both parties agree that if there's ever a dispute between the parties, that you'll bring the claim against the other within 6 months. So you basically write your own statute of limitations, and the advantage to that is the statute of limitations on some claims, especially in Ohio, is up to 6 years, and you don't want to get a letter from somebody 5 years after the fact saying that they did this, that, and the other, or you did this, that, and the other to them while they were employed, and you'll be lucky if you can even match the face up with the name by that point. So, so I call that kind of an agreed-upon statute of limitations. And that, again, there's lots more things you can do. You can have an employee handbook, and if you had 5 or 10 employees, you probably want to have an employee handbook that had more detailed policies and expectations. But that's a good starting point, even if you only have a few employees. Then about the next one down is explain the company's policies and procedures. All right. Now again, I'm an employment lawyer, so I'm coming at this from an employment law standpoint. Obviously, you want to explain to the employee about what's expected of them in the job and how to do it. But as far as from a personnel standpoint, even if you don't have a formal handbook, which isn't necessary, and for small, very small employers isn't typical, but you want to explain when payday is, kind of who's in charge, different things like that. What fringe benefits may be offered, if any, or their paid vacations, sick leave, etc., and whatnot. This last bullet point would only apply about a general COBRA notice if you had a health plan that you were offering. And most of that would be covered by whoever you bought the health plan from, so I won't go into a lot of detail with that right now. Okay. All right. Now, I told you I'd come back to employment applications. Again, you don't have to have employment applications, but if you do, well, for one thing, I can email you one if you send me an email. I have a template application that I like to use, and you're more than happy to have a copy if you send me an email. My email address is on the front page of the materials. But here's some things that you need to have in your application. You need to have an at-will statement. Again, we talked about that. This is what says employment isn't offered for a specific duration, and anybody can terminate the relationship at any time, with or without notice and with or without cause. An acknowledgement that if you lie on the application, and we find out, we have the right to get rid of you, because that might mean, probably would mean that you hired them based on a certain representation of their experience or their qualifications, and if they lie to you about those, you have a right to get rid of them. A notice of drug and alcohol testing. Again, this is only if you're going to do drug and alcohol testing, so I'll only get into that if there's specific questions. And a reference release. This is if you're going to check references. So again, if you're not going to check references, I wouldn't bother with this, but this would be a statement that essentially says we're allowed to look into your background, and if we do, you're not going to come after us or the person we asked for information from. All right. So next is how to do interviews. This is not complicated, but there are some pitfalls that you want to stay away from. First, some general things. When you sit down with the interview, try to put the person at ease. I find when I've interviewed people, if you share some information about yourself and about what your goals and objectives are, kind of opens them up and allows them to do the same, encourages them to do the same. You state the purpose of the interview, remind them what the position is that you're looking to fill, and why. And it looks like Beth has a question here about harassment that I just noticed, so I'll turn it over to Beth for a second, and we'll come back to interviews in just a minute. Beth?
Yeah, so one of our participants is asking, when you say if they need to, when you need to spell out who they need to contact when there is a harassment issue occurring, an instance of harassment, do you mean that there is an outside of the employer contact they need to contact, or somebody within the business that they need to contact?
Yeah, that's a great question. That's a great question. I'd be happy to clarify that. The document that I'm suggesting that you distribute would explain to employees who to contact internally to make a complaint of harassment or discrimination. And typically how those would go is in a large organization, it might say to make a complaint to your supervisor or the Human Resources Department or the President, for instance. Because you never, if you can avoid it, you don't want it to be just one person, because if that one person is the person that's harassing you, that isn't going to get you very far. So if somebody's the boss at your farm and it's clear that one person is the boss, that would be a good person to report it to. I realize that some of these employers and the attendees maybe on the small side as far as management. So even if there's if it's a husband and wife team running the farm, you can have you know, a backup person. It's a little smaller. It's a little harder in a smaller organization, but that's a good question. You want the point of contact to be internal, and I'll expand on that just a little bit so you have some background. The reason why you want somebody internal is because the way the law looks at, we'll take sexual harassment, for instance, is if you have a policy in place that says that we prohibit harassment based on a protected characteristic like gender, and we have a procedure for reporting complaints of harassment, and we have a policy that when we get a complaint, we investigate it, and we take prompt, appropriate action to remedy the harassment, to make the harassment stop. And the employee does not complain internally, and then goes on and on and on, and after you fire him for stealing from you is usually how this happens, or something like that. The employee then complains to an outside agency, oh, I was harassed the whole time I worked there. You know, it went on for months and months and months, and I didn't know what to do. You have what's called, in lawyer language, an affirmative defense. It's kind of like a get-out-of-jail-free card if you can show that you had the policy and the reporting procedure and the person did not take advantage of the policy and the reporting procedure in an attempt to mitigate their damages and make it stop. Instead, they just, quote-unquote, endured the harassment. That's a very, very powerful defense in those cases. Now, all that said, is there anything to stop an employee from going to an external complaining to an external agency or an attorney, for instance, when they think like they're being harassed? Absolutely not. Especially with the advent of the internet these days, if you type in to a Google search, for instance, sex harassment Ohio. Here, I've never done this before, but I have my iPad, and let's see if you get, I'm going to predict you get the Ohio Civil Rights Commission. Close. You got the Ohio Bar Association, and then some websites for attorneys that will be happy to talk to you about your case. So, so hopefully that addresses the question. All right. So that was a good question about harassment. So back to the interview a little bit. Again, you want the person to open up. You want the person to do a lot of the talking, and you want to ask questions with why and how. Like, why are you interested in working here? You know, how will you apply your previous experience to what we're doing here at the farm? That kind of thing. All right. So I will not go through the next several slides in detail, but I do want to tell you about what you have here. Is over the years at our firm, there's several of us here that we all practice employment law, but there's several of us in particular that work on these types of issues as far as maintaining lawful hiring practices and disciplining and discharging employees in a lawful manner. And over the years, we've come up with this kind of do's and don'ts of interviews. This would be a good tool to read over, for instance, before you do a battery of interviews. And this whole chart really is, for the most part, geared to keeping you away from making an employment decision for an unlawful reason, like age, national origin, marital status, race, things like that, pregnancy, that's another one. So we'll just go through a couple of these and I'll just give you a little bit of an explanation. And as you'll see, there's several subject matters listed here. They go on for pages. And then what kind of questions you're allowed to ask and what kind you're not allowed to ask. All right, so like residence, for instance, you really only need to know where the person lives, their current address. That's appropriate to ask on an application or an interview. And how you can reach them, phone, email address, that type of thing. You don't need to know who they live with or whether they rent or whether they own. Their age, again, their age. You only need to know whether they're old enough to be eligible to work as an adult, so you need to know whether they are 18 or not. And even you might be able to employ certain employees under the age of 18. And then you're allowed to ask after you hire them for proof of age if you think that's necessary. You don't want to ask somebody at an interview how old they are, because if they don't get the job and their answer to how old they were was a number that's greater than 40, those people are protected under the law, and you don't need to know whether they're over 40 or not. You just need to know whether they are eligible to work. All right. National origin. There's no reason to ask about that, Zippo, because again, you'll check on the I-9 whether they are eligible to work in this country, which is all that really matters. Race, there's several references in here to affirmative action plans. That is not likely something you're going to have to get into, so I would not worry about asking about somebody's race. Sex is probably obvious. You don't need to know their religion. You don't need to know if they are pregnant or if they've ever been pregnant before. Again, citizenship, you need to know on the I-9 whether they are eligible to work in the United States after hiring. Marital status, these are, and number of dependents, these are after hiring questions that you need to know for insurance and tax purposes. You should not be asking somebody during an interview if they're married or how many kids they have. Let's see here. Criminal record, important one. Do not ask how many times they've been arrested, because it doesn't matter if you're arrested or not. It matters if you're convicted. And then if you ask about convictions, which you don't have to do, but you can, you give them an opportunity to explain the circumstances. You can't have a blanket prohibition against hiring somebody with convictions. The United States Equal Employment Opportunity Commission has determined that disqualifying people based on convictions in general, just as a blanket rule, is tends to discriminate against racial and ethnic minorities like African Americans and Hispanics. So you should not be asking about arrests, and you should not be disqualifying employees or applicants based on whether or not they have a conviction, only upon the nature of the conviction, how long ago it was, etc. All right, so let's see here. Work schedule. Yeah, you don't want to inquire about what religion they are. You just want to tell them what the work schedule is and ask whether they are able to meet the schedule. You can't ask about military reserve obligations. All right, so that is a whirlwind tour of acceptable and non-acceptable interview questions. And there's just a couple of other slides here on hiring practices before we get to the wage and hour questions that we'll close with here in the last 30 minutes or so. All right, and we referred to this kind of on the fly earlier, but we'll get a little more detail here. Medical exams and drug testing. All right, as I mentioned before, you are not required to do drug testing ever. If you want to do drug testing, you can do it after you offer somebody a conditional offer of employment. You can do drug testing. There's lots of groups out there that do drug testing clinics and whatnot. These are not hard to find. And they will tell you whether the person is engaging in the use of unlawful drugs. And you may not want to hire the person if they do that, and you can make that clear that their conditional offer is contingent upon them passing the drug test. All right, so let's talk about medical exams. You cannot do a medical exam pre-employment. You can do a medical exam post-offer, a post-offer physical, but that's only if everybody in the same job classification is required to do the exam. You can't, for instance, say, boy, that person seems like they have good skills, but they seemed a little feeble or weak, so I'm going to put them through a physical to see how they do. You can't discriminate. You have to do it with everybody or do it with nobody for the post-offer physicals. Again, not a requirement. Now, post-employment, this is after somebody is actually working for you. You are allowed, and this is I should have mentioned this earlier, but our office and me in particular, we represent employers of all sizes, big and small. And a lot of employers of all sizes are not aware of their rights to request a medical exam for an existing employee. Now, it doesn't come up all the time, but this would be, for instance, I'll give you an example of an employee who's worked with you for a few years, and the employee, say, for instance, suffers an accident away from work, and they come back to work, and their doctor clears them for work. This, again, is an example. They bring you a slip that says, John may return to work without restrictions on June 1st. So on June 1st, John shows up to work, and you notice that while he used to work all the way through the day with only maybe a half hour to eat lunch, and now he can barely catch his breath, and every 5 minutes he's bent over at the waist, and he appears to be in distress. That would be a time to get John checked on by an independent doctor that is not his doctor. There's a lot of options here. They might not write books about this, but they write chapters of books about this, and it probably wouldn't do me justice to kind of explain each little avenue that you can go down because it is kind of complicated. But the important takeaway here is if you have an employee and you have a good faith belief with your judgment that the employee cannot perform his or her job due to a physical or mental impairment perhaps, or is putting themselves or other employees, including you or people around them, customers, in peril because of their physical or mental condition, you are allowed to remove them from work, and you are allowed to send them to their own doctor for clarification that they are able to perform the essential functions of their job, and or to an independent physician to get an opinion from there. But again, it's a little more complicated than that, but for the time we have here, that is just something that you should know, that if that happens, the red flag should go up, and you can consult with a human resource or employment counsel on what steps to take next. But the next step is not to pretend like you don't notice the person in distress. That is not a good idea. Or to pretend like you're a medical doctor and you evaluate the situation instead of having a physician do that. So that was medical exams and drug testing. The next few slides are on wage and hour law, Fair Labor Standards Act. We have about 25 minutes to go. I'll pause there to see if Beth has any other questions, either from herself or from the attendees.
Yeah, Tom, we are good to go. I don't have any questions coming in, so we can keep rolling.
All right, great. All right, so now we've talked about who is an employee, who's a contractor, how to hire an employee, what you need to do once you've hired an employee, what you might want to do once you've hired an employee, even if it isn't required. And now we're going to talk about how to pay an employee. Now, I'll go over a couple of general rules, but the agriculture business has its own particular set of rules, so we'll talk about that for a few minutes too. All right, in general, employers are required to pay non-exempt employees minimum wage for all hours worked. Let's break that down just a little bit. The distinction between non-exempt employees and employees, again, is something that they write chapters of books about. But you may hear the distinction between salaried employees and hourly employees. That's a little bit of an overgeneralization, but that's the distinction we're talking about here. So there's only certain employees that can be exempt, and meaning that you can pay them a salary, fixed salary for each week, and that covers all their hours worked. And those are generally people that are in management or professional people that are attorneys, actuaries, clergy, things like that. Non-exempt employees are everybody else. These are generally people that are paid by the hour, and non-exempt employees, as a general matter, are subject to the federal minimum wage, which is $7.25. Or in Ohio right now, the minimum wage is $7.85. And you might say, well, which do you pay? Well, chances are you owe the higher of the two, which is the Ohio minimum wage of $7.85 an hour. Again, this is in general terms. We'll get on to how this impacts agricultural employers in particular. Also, with non-exempt employees, let me drop a footnote in here. This would not apply to contractors. We're only talking about employees now. If you've made the decision to hire a contractor, you can pay the contractor, frankly, any way you want. You can pay him by the job. You can pay him or her by the hour if you want. But none of these rules, these Fair Labor Standards Act rules, would apply to somebody who is a legitimate independent contractor. All right, so then that was the end of my footnote. You're also required to pay non-exempt employees overtime pay for all hours worked in excess of 40 per work week. Work week is any consecutive 7-day period, regular recurring. So you can go Sunday to Saturday, Friday to Friday, whatever you want. And it's measured in a work week, so if they're under 40 hours in a work week, they don't owe any overtime, and if it's over 40, you do, in general. The 8 in a day kind of a thing, you may have heard of people that get overtime after 8 hours in a day. You're certainly allowed to pay people overtime for hours worked over 8 in a day. Some states have requirements that you pay overtime for hours worked over 8 in a day. Ohio does not. And some employers are obligated to do that through a union agreement, a collective bargaining agreement, but not as a matter of law. So, but here's the best news all night. Many agricultural occupations are exempt from some or all of the requirements of the Fair Labor Standards Act. So what this means is much of what I just told you may not apply to your business in agriculture. I'm going to jump one slide ahead here real quick and then jump back. There we go. The Fair Labor Standards Act definition of agriculture is extremely, extremely broad. So anybody who is in any type of farming, I'm going to sneeze here, excuse me. Oh, it may have passed. Any type of person's in a farming business probably is not going to be covered by, or is going to be eligible for some of these agricultural exemptions. Okay, so here are some of the exemptions, but we'll get into more detail here. Agricultural occupations may be exempt from minimum wage and overtime only, different child labor requirements, and so forth. So let's see. Okay, so I have some more detailed information on some of these exemptions. There's an exemption found in Section 13A6 of the Fair Labor Standards Act. This generally applies to agricultural workers employed by small farms, and they define small farms as farms using no more than 500, what they call man days of agricultural labor in any calendar quarter during the previous calendar year. And a man day is defined as any day during which an employee performs any agricultural labor. So if you don't meet this threshold, then you are, according to Congress and the Fair Labor Standards Act, a small farm, and you do not have to abide by the minimum wage and overtime requirements of the Act, which is pretty significant. And I can't say in all candor that I've applied this particular exemption, but I was kind of doing some brainstorming the last couple days. And one way that you could apply this would be instead of paying people by the hour at minimum wage or higher to work at the farm, you could pay the employee just a fixed salary, fixed fee for each day or each week employed, and then that would cover all the hours worked. I will give you a tip here, though. I think it's always a good idea to have an employee maintain time records, even if you aren't required to abide by the minimum wage and overtime requirements. Because if there's ever a fight about if you are exempt from the Fair Labor Standards Act requirements, it would be good to have those time records available to you. There's also an immediate family exemption. So this would be any of your immediate family members are not, you're not required to pay them minimum wage or overtime. And the immediate family is defined as parent, spouse, child, stepchildren, foster children, step-parents, and foster parents. Importantly, even if other relatives live in your home on a permanent or indefinite basis, they would not be considered part of the immediate family for the purposes of this exemption. And there's some other exemptions here. One of them is called the hand harvest laborer exception, and this allows you to pay people that are doing manual gathering or severing of the soil-grown crops from the soil, stems, or roots in the field. You can pay them a piece rate, which means you can pay them by the piece for everything they're picking in the harvesting context. And there's some other ones here for migrant hand harvest laborers under 17 years of age, and for folks that are working with livestock. So again, these are very specific to the type of work you're doing, and you would probably want to have a little bit more specific opinion on how you should and should not pay somebody depending on your operation there. All right, so let's see here. And there are also a couple others which may not may not apply. Let me look at my notes here to all of you. For instance, this under 13B5 of the Fair Labor Standards Act, somebody who is a buyer of agricultural products is not subject to overtime, and this is pretty wild. If you're employed in agriculture, this is under 13B12, if you're employed in agriculture but you do not apply to any of the agriculture exemptions that we already discussed under 13A, you are still exempt from the overtime. So you still have to pay somebody at least minimum wage, but you would not have to pay them overtime for any hours worked over 40 in a week. And I know we still have a few more minutes to go here, but that was the end of the prepared material I had. Beth, if you have some questions, we can take those now. Otherwise, we can either finish up, or I have a couple of other finer points that we can talk about.
Well, I do have one question in terms of, what's permissible for an interview. And I have talked with a couple of farmers who are interested in doing something like a working interview, where they are they have the applicant come out to the farm and spend the morning with them, either in the high tunnel or out in the field, doing various tests to see basically what their capabilities are. Is something like that permissible?
Yeah, that is a great question. Well, let's see. It would depend. The answer is usually it depends. And I'll tell you what a few of the things it depends on. One is it depends a little bit on your risk tolerance. You wouldn't want them to be doing anything that was extremely physically strenuous, in that there might be a chance for injury. And even though they were not quote-unquote hired yet, it might get a little tricky, back to this workers' compensation thing we were talking about. It might get kind of tricky if the person is injured and you don't have workers' comp coverage. Then it would get real tricky. Even if you had workers' comp coverage, though, and they were injured, it would be difficult, or at least it would be dicey to claim that they weren't in the course and scope of their employment, if in fact they were doing strenuous work, because usually you don't have somebody doing strenuous work when they're not even employed yet. That may be covered if they're not employed. It still may be covered by some general liability insurance that you have on your property, but that is so you just need to be careful with kind of how carried away you get with that type of interview. The other thing to consider with that is whether you are trying to screen out employees that may have disabilities, and you do not necessarily want to do that during the interview process through any type of like an agility test or anything along those lines, unless it's very, very closely monitored. One thing that you could do to find out if the employee is able to do the work, and I know this isn't the same, but to ask them if they have done the work before, and or tell them what work is going to be done, and say, are you able to do that? Because if it is an essential function of the job, then they're required to do that. It would really depend. It would get right down to the nuts and bolts and exactly what the employer wanted the employee to do, and the reasons for it, but that's probably a close call.
Another question we have is whether or not workers' compensation is required for part-time, short-term people or anyone under the age of 18. And also, I would have a question too as to whether or not it's required if you have volunteers at any point come out to your farm. I know that some community-supported agriculture farms, where essentially their customers are shareholders and their return on investment is food, do you need to have workers' compensation if those members of your farm come out and work and, in the event that they would be injured?
Yeah, that's two good questions. On the first one, the Bureau of Workers' Comp coverage is required for all employees, whether they be part-time, short-term, long-term, under 18, over 18. So you need to have workers' comp coverage for all of those people. Now the second question is also a very good question, and there's a few different ways you can handle that. One is there is a document called the Bureau of Workers' Compensation recreational waiver, and it doesn't fit this situation perfectly, but that is something that you can download off the Bureau of Workers' Compensation website. I just found it on my iPad by typing in Ohio BWC recreational waiver, and it was the first hit on Google. Now this speaks to employer-sponsored activities and programs. Again, not perfect, but it would be something that you could have the person sign kind of on the way in to acknowledge that they're doing this not as an employee, but they're just doing it as a recreational or other programmatic activity. Another thing you could do kind of separate to that is, and I've signed a couple of these in my time, although I can't think of where or what they look like, but put together kind of an acknowledgement document that you have everybody sign on the way in that says something to the effect of they accept kind of a waiver document. They accept responsibility for any injuries that they would sustain, and they're not, the farm is not liable for their injuries, that type of a thing. So those would be two documents that you could have everybody sign. In fact, I think through some volunteer work that I've done with the National Park Service, I think they have some waiver documents that they have people sign when I've done some volunteer work for them. So that would be good, because really that would get you to the point where it was clear, if there was an injury, that you had a understanding between the two parties ahead of time that this wasn't an employment relationship. And even with the BWC waiver, let me mention, you can use that, and actually the form is designed to be used with employees. So that's even something that you can do if you have employees that are doing a different type of activity than their job. And I'm going to try to go back into my memory banks here. I know I've done this for the classic example is the company picnic. I was trying to get one that would line up specifically with the farming type business, but say you had an employee at your farm, and the trade group that the farm was in, the Ohio Association of Farms or something like that, was having a fundraiser, and they were looking for volunteers to staff the fundraiser, and an employee of yours said, I'd like to do that. You could have them sign the BWC waiver to make it clear that their work as part of that fundraiser is completely voluntary and does not part of their job, that type of thing.
Okay. And then also a question about compensation. Is monetary compensation the only kind that is acceptable, or are there instances where you can pay your employees with housing or with room and board kind of an arrangement? What is allowable in those terms?
Yeah, another great question. I've looked at those issues a couple of times. In fact, both of them fairly recently. The short answer, it's a long answer, but I'll boil it down. The short answer is that yes, you can pay employees through room and board, through lodging, and I believe meals as well. I'd have to look up that for sure. I'm sure you can pay them through lodging. I'm going to try to look on the fly here and see if I can pick that up. And it, like most things, there's a little bit of my politics showing. When you get the government involved, it gets a little complicated. There's a lot of rules and regulations. You can't just do it, what I'll call it, willy-nilly. But yes, it can be done, and you can take a credit basically for, here I just found some information, for meals, lodging, and transportation under certain conditions, provided that you follow the regulations and whatnot. So yes, it is possible to pay somebody by some other means other than just money.
I'd like to encourage anyone, if they have a few last questions, to go ahead and send them in. Otherwise, Tom, do you have anything else to add?
Well, I'll just give you one tip in addition to all this that we've discussed today. The biggest favor you can do for yourself once you have employees, if the employee is not living up to your expectations. And this sounds so simple, and it is. I know it takes time, and that's usually what gets in the way, but you need to document that the way the employee is not living up to your expectations, and share that information with the employee, and then mark your documentation as to when you did that. Because in the long run, whether you need to get rid of the employee because you need to find somebody else that will live up to your expectations, and whether the employee applies for unemployment insurance, and a bunch of other reasons, whether they accuse you of discrimination, the best tool an employer can have is notes as to when they advised the employee that they weren't following the rules, what the expectation was, and what the consequence was if they didn't live up to the expectation. Now, if you were General Electric, I wouldn't tell you this because the level of sophistication at an employer like that, not sophistication in general, but as an employer, because they have thousands and thousands of employees, is a little different. I wouldn't tell them to do this in a notebook, you know, but it is literally as easy, and I've advised employers with just a handful of employees to do this, to keep a notebook someplace that's handy, and maybe next to your bed or whatever, or in your office, and you just record in there, you know, different expectations you shared with employees, and why you did that, and the discussion. And down the road, when the employee claims they didn't know anything about that, you have this nice detailed time and date stamped log of all the discussions that you had with the employee.
Okay, well, it looks like we don't have any more questions. So I'd like to thank you, Tom, for spending an evening with us sharing some of your, I'm sure, just scratching the surface of your knowledge here in terms of employment law and how people can go about bringing employees onto their farms. And also give just a short reminder to the participants that if you would please take just a couple of seconds and fill out our survey at the end of the presentation here, it would be much, much appreciated. Also, by the end of next week, and potentially sooner than that, we should have this presentation up on our website, and I will send all of you a link to that when it is up and ready to go. So thanks, everybody, for participating.
And thank you,
and
Beth.
Thank you, Tom.
Yeah, thanks to you and Katie and everyone at the Countryside Conservancy for inviting me, and I enjoyed it.
Great. We're happy to have you. So thanks, everybody, and enjoy the rest of your evening.